Hello and good evening, everyone. Welcome back to another class from Family Law. And on behalf of Livelaw Academy, I welcome everybody. Today, the topic is going to be effect of a valid adoption under Hindu Adoptions and Maintenance Act. It is one of the important areas from judicial services point of view and also in terms of practice. One should know what are the implications of a valid adoption. I have structured this class with emphasizing more on the effect of adoption. I'll be touching upon other areas of adoption as well, but just for the sake of understanding, we will not be getting into the details of the same. And at last, I will also be discussing one of the most practical practice related problems that one come across when um, the issue of adoption is concerned. It is related to the change in caste of a person and resulting issues, particularly the benefits regarding reservation. Okay, so let's get started. Yeah, okay. So, as I said, let's briefly understand some of the background things in order to completely appreciate this topic. Let's discuss about the objects of adoption first. So, adoption has twofold objects. It one of the objectives that it has is that it has is spiritual in nature, or one can say religious in nature, right? And under this, it is seen as a tool to secure spiritual benefits to the adopter, and not only to the adopter, but also to the ancestors of the adopter. As we have seen in the previous one of the previous lectures, that one of the objectives of human life is to secure benefits to the ancestors after life and to ensure that they take a rebirth to repay their debts and they can achieve the final state of salvation. That is the objective of the human life in the first place, right? So it has the adoption also has this religious value because it helps in doing so by providing you a tool by through which your family lineage can continue, and you can ensure the spiritual benefits not only in respect of yourself but also your ancestors. The second objective of adoption is secular in nature, which simply means that one can adopt a person, be it male or female, in order to secure an heir for oneself and to ensure that the name of the adopter it perpetuates, it continues, right? The legacy basically continues. So these two are the fundamental objectives under any kind of adoption. Then let me just quickly address the effect of Hindu Adoptions and Maintenance Act on the overall uh, subject of adoption. Before Hindu Adoptions and Maintenance Act, we had traditional Hindu law, which was governing the issues like who can adopt and who can be adopted, and whether the adoption can be cancelled or not. The adoption has to undergo what kind of ceremonies in order to be recognized, in order to be valid under the law, right? So, under traditional Hindu law, there were variations, and one fundamental difference between Hindu Adoptions and Maintenance Act and the traditional Hindu law is traditional Hindu law was gender biased in the sense that under the traditional Hindu law, it was only the male that could be adopted, and the adoption of females was not allowed. And similarly, it was only the father, the husband, that could have adopt a male child. Though in certain areas, under certain conditions, the females were also allowed to adopt, but only under the express authorization from the husband, and that too after his death in most of the cases. So, Hindu Adoptions and Maintenance Act, which came in 1956, it has brought a sea change in this particular area of law, and it ensures that it is not gender biased. It should be based on the principles of equality, because these family laws, they came 1955 onwards, and before that we adopted the Constitution of India, under which we have promised that our society must be based on equality, where we must ensure justice for everybody. So we cannot afford to have laws which are gender biased. So on the same lines, Hindu Adoptions and Maintenance Act also ensures that in cases of adoption, the bias is addressed, and there is no bias as such. The male as well as the female can be adopted, and the male as well as the female can adopt under certain conditions. In fact, both males and females are allowed to give the child in adoption, right? But basically, they subject to the provisions of the act, obviously, right? So, Hindu Adoptions and Maintenance Act, it says, it prescribes that now the adoption has to be in accordance with the provisions contained in it, which means the traditional Hindu law is no longer applicable. But here we must keep in mind that the effect of Hindu Adoptions and Maintenance Act, when we read section 4 and 5, which to which we will be referring at a later stage in today's class only, right? We find that it has prospective effect. So previous adoptions, they will still be regulated by the traditional Hindu law, right? So any adoption after the commencement of the act will be according to the provisions of this act. Otherwise, if the provisions are not followed, then the adoption will be a void adoption. It will not be recognized under the law, right? Validity of adoptions previously made is not effective. This I've already told you, and we will again referring to this particular point, this principle again in the subsequent slides, right? So before moving on to the effects of valid adoption, let me just quickly give you an overview of the Act. It prescribes certain definitions on whom the Act should be applicable. It tells you what is the operation of the law, whether it is prospective or retrospective. Then it lays down the conditions for a valid adoption, including who can adopt, who can give an adoption, who can be adopted, and certain additional conditions for a valid adoption pertaining to age gap, etc. It also tells you the effect of registration and everything. It also has a saving clause, but those provisions of the Act are not subject matter of today's class. We will only be addressing now the effect of valid adoption. Who can adopt, who cannot adopt, who can give an adoption, who can be adopted. They are subject matters of different classes, and they will be dealt in due course. Right. So let's move on to the effect of valid adoption. Here I have bifurcated this topic into two subtopics. What was the traditional view? We'll understand that first, and how this position has changed under Hindu Adoptions and Maintenance Act, or rather, is there any change as such, or the same has continued? Right? We'll examine. So let's start with the traditional view first. As per the traditional Hindu law, adoption was seen as a transfer of a child from one family to the other. Now, here the child means only the male child, right? As I've told you that it was so gender biased, females were not allowed to be adopted. So, and there are cultural reasons for this. The boy was only seen as an instrument to achieve salvation, right? The boy can only ensure that the lineage continues. The boy can only make religious offerings, including the pindan, etc. Right? So only the boy was allowed to be adopted, and once the adoption was made, it was deemed to be a complete transfer from the family of natural birth to the family of the person who is adopting, the adoptive family, right? So the child gets transferred completely from his natural family to the adoptive family. Here, you can compare. the process of adoption to the transplantation of trees and plants, just as a plant is uprooted and it is replanted somewhere else, and then it grows at the new place, right? With obviously with the care and extra efforts, right? Similarly, in adoption also, a, a person is sort of uprooted from the family of origin and then transplanted in a different family, in a completely new family. The child grows in the new family. The ties with the previous family are completely severed and they are replaced by the ties that the child will now be having with the members of the new family, with the members of the adoptive family, right? Please keep in mind that in case of traditional view, when I'm referring or when I'm using the word child, I'm only referring to the male child. Okay. So when the ties are severed from the previous family and now new ties are created, uh, it results in rights and privileges imported on um, the male child. They will be same as the child would have had or enjoyed in case he would have been a legitimate child by way of natural process, right? Same rights and privileges will be granted to such a child, which means now he can inherit as an heir in the new family. Now if the joint family has a joint Hindu family property and he comes within the first four generations, the top generations, right? He will also enjoy in the same fashion as he would have enjoyed if the ties with the um previous family they have been severed. Right now, he will not be able to inherit as an heir of the father or any other natural family member as the ties are completely severed. And similarly, he has to give up his coparcenary rights if he had any in the previous family, right? So here I'm talking about sin. On one hand, he is gaining some rights. On the other, he is losing the rights from the family of birth, right? So these includes right to claim share in the property of family members from natural family, including the share in the coparcenary property. This we have already discussed, right? But before moving on to the position under Hindu Adoptions and Maintenance Act, we should also address an issue um, that under traditional law, what was the position with respect to the property which was already vested in a person before his adoption? What will happen to that property, right? Let's say a person A who was in X family, right? And X had the family had joint family property and there was a partition of the joint family property and A was one of the co-parceners, right? So naturally as a co-parcener उनको कुछ share मिला होगा, and when you get a share from the co-parcenary property upon partition, the property uh, changes its nature from joint family property. That portion, that share that you'll get, it becomes your self-acquired property, right? So it gets vested in you completely. After the partition in the natural family, A was given in adoption to a family Y, right? Now, what will happen to the share that was already vested in him, right? Will it continue to vest in him, or he has to give up this property which was vested by way of partition, right? Or it could have been any other property. He could have received it under a gift, under sale, right? So not only proprietary property. The discussion includes every property, every kind of property which was vested in the person before his adoption, right? So what will happen? We have a case here which was decided by the Madras High Court in the year 1906. Now, I've picked this particular case. Why? Because we are right now dealing only with the traditional Hindu law. So before 1956 case has to be discussed. So in this case, Sri Raja Narsimha versus Sri Raja Rangayya, 1906 Madras High Court, it was very clearly laid down that the severance of relationship with the previous family will not result in giving up rights in the property that were already vested in the person. If the property was already vested, it will continue to vest. If in a joint family properties case, the partition had not taken place before the adoption, right? Which means the interest in the family property of the person concerned still remains a fluctuating interest. It was not crystallized through partition, and the person gets adopted before the partition, then only he has to give up his rights in the interest in the co-partner property, because it was not vested. It was not vested. He can be a co-partner if there is a possibility, right, in the new family, but the co-partner rights in the previous family have to be given up. The person will lose such a right, right? But if the partition had already taken place, or he has received any property through any instrument, the property is now his property, either under partition in case of joint family property, or otherwise in case of any other kind of property, it will continue to vest in him, right? That status will not be changed. And a similar view was taken by the Bombay High Court in the year 1950, where there was a partition between grandfather, his sons, and grandsons, right? So the situation was like this: we have a grandfather, let's say he had two sons, A and B, and then he also had grandsons C, D, and E. And upon partition of a joint family property, since all of them are, they form coparcenary, right? So shares have to be given to everybody. So property will vest, some part will vest in grandfather, some in the sons A and B, also the grandsons C, D, and E. All of them are the coparceners, right? So there was a partition, and all of them receive their respective shares. Now, when they receive their respective shares will take the nature of a self-acquired property. It will no longer be a joint family property. After the partition, one of the grandsons got a share on partition, was subsequently adopted into another family. So let's take, for example, C, right? C, he got adopted in the new family after the partition is it is happening, right? So in this particular case, Bahinbai versus Kisalal, the Bombay High Court followed the same kind of approach which was followed by Madras High Court, and again laid down that once the partition has taken place and adoption takes place subsequently, the property being the being in the nature of self-acquired property now will continue to vest in such a person. If the partition had not taken place, then he uh, could be said that the opacity rights are no longer available to him, right? But here the situation is similar to what happened in a case before Madras High Court. The same principle was applied. So C's property, C's share that he got through partition, it was allowed to continue to vest in him only, even after the adoption, because adoption took place after the um, partition, right? Then I have laid down few illustrations here in order to understand the traditional position in a better way, right? So let's discuss them one by one. In the first illustration, A has two sons, B and C. B and C. A gives C in adoption to the one X. So now, as per the law that we have discussed, the ties of C in A's family, they will be severed and they will be replaced by ties with the family members of X, right? So A gives C in adoption to X. Here, C will not be entitled to inherit to A as his son because the relationships have completely changed. A, if he has self acquired property, if the adoption was not there, then both B and C as heirs could have succeeded to the property after his death, right? A can give the property through will. That is not an issue here. But as an heir, C will not succeed to A's property because now upon adoption, he is no longer the son of A. Rather, he is now a member of a completely different family, the family of X. So only B can succeed to A's property as an heir. This was the first illustration. Let's move on to the second one. Here, A and B are two brothers and they have sons C and D, right? So let's say A and B, they were the two brothers, right? And they have C and D as their sons. A gives his son C in adoption to X, right? A gives his son C in adoption to X. Now, if in this particular scenario, they had a joint family property which was not partitioned, so all of them, the two brothers and the two cousin brothers, they would have formed coparcenary, right? All of them would have been treated coparceners. But here the illustration simply says that the adoption took place and now C belongs to the family of X, severing all his ties from the family of A, right? So let's move with it with this presumption that no partition took place. So now C, having adopted before the partition, right, his coparcenary rights will no longer be available to him in his natural family. Though, if he falls within the topmost four generations in the excess family, he can be a co-partner in the new family. But now he has to give up his right as a co-partner in the previous family, in the natural family. So earlier, the co-partners which was formed by four members, now the co-partner will continue only with these three members, A, B, and D. This is the meaning of illustration number 2. Then let's move on to the third one. A and his son B are members of an undivided family. So here we have only two people. A dies and on his death, B becomes entitled to the whole property as sole surviving co-partner. Now, when we say sole surviving co-partner, it means that the illustration number 3, it is also talking about joint family property, right? So earlier there were two co-partners, father and son. Now after the death of father, right, it is only B who is surviving and now he is the sole surviving co-partner. Now the law with respect to sole surviving co-partner is when there is only one co-partner, the entire property belongs to him as if he is the sole owner, right? He can deal with the property as if the entire property is his, as if it is the self-acquired property. It is not a joint family property, right? So, in such a scenario, when only one co-partner is left, now the property will vest in him, and he will have the complete 100% ownership over the property. There is no longer a fluctuating interest. Now the property vests in him, right? After that, B's mother, इनकी mother जो है, यानी A's wife, B's mother gives him in adoption to X. Here, C does not lose his rights in the coparcenary property. The reason being, it was already vested in him. There was no fluctuating interest, right? As held by the high courts of Bombay and Madras in these two cases, that once a property has already vested, after the adoption, it will continue to vest. However, in case of joint family property, if there was no partition and earlier in the natural family, the child enjoyed rights of copartner, right? The rights have to uh, be given up and उनको बाय बाय उस राइट को करना पड़ेगा and now the new rights will be created. The interest in the coparcenary property will no longer be available. So in this case, in third illustration, after the death of the father, there was only one co-partner left, the son, B, right? And he took the property as a property belonging to him only as per the rules of co-partnery, right? उनके पास ही सारी property होगी. He will enjoy the ownership rights 100% without any limitation till a new co-partner is added, right? It will be his own private property. He can deal with it in any way possible. He can just dispose it off. He can continue with it and use it in whatever fashion he deems fit, right? After this has happened, now there is an adoption. So this adoption will not affect the rights vested in him already, right? He will continue enjoying the same right with respect to the property. Now we have to discuss what is the position under Hindu Adoptions and Maintenance Act. And for this, we have to refer to section number 12. So let's see what section number 12 actually prescribes. Yeah, section number 12, it deals with the effects of adoption. An adopted child shall be deemed to be the child of his or her adoptive father or mother. First thing that section 12 prescribes, it creates a legal fiction, something which was not there in reality, but for the purposes of law, it has to be treated as a reality. So there is a deeming clause here. There is a legal fiction here. Section 12 says an adopted child shall be deemed to be the child, which means now law is clothing the person adopted with some rights. It is done through the instrument of legal fiction. And what are those rights? To be the child of his or her adoptive father or mother, which means he or she. Now that I have told you that under HAMA, Hindu Adoptions and Maintenance Act, both the genders can be adopted, right? So if a male or female has been adopted, they will enjoy the same rights, they will enjoy the same privileges, same position that are available to the naturally born son or daughter, right? They will be deemed to be the child of their adoptive father or mothers. Next thing that section 12 prescribes is that this deeming, this legal fiction takes effect for all the purposes. Now, for all the purposes means there is a complete transformation, there is a complete change in the life of the person adopted for all the purposes, including the succession to property as an heir, including creation of co-partner rights. Everything, every effect will take place as if the child who has been adopted is a naturally born child, naturally born legitimate child, right? For all purposes. But from what date this effect actually takes place, and this is very important from prelims point of view. They asked this question from the Berak language. right? It takes place from the effect of, it takes place effect, it takes effect from the date of the adoption, right? And from such date, all the ties of the child in the family of his or her birth shall be deemed to be severed. Again, there is a deeming clause. Deemed to be severed and replaced by those created by the adoption in the adoptive family. So, under the traditional law also, the situation was same, the position was same, right? Section 12 actually repeats whatever we have discussed under the traditional Hindu law, right? Traditional Hindu law also provided that upon adoption, there will be a complete transfer of one child from one family to the other, right? The ties from the previous family will be severed and they will be replaced by the ties created by the adoption in the new family. Now, same thing is provided under Section 12, right? So it deems the child to be the naturally born legitimate child for all the purposes from the date of adoption, and all the ties from the previous family will come to an end, and they will be replaced by ties created with the new family, right? Okay. Okay, so we have seen Section 12. Yes, it establishes the same legal transformation as was provided under the traditional Hindu law. Adopted child, he becomes the lawful child, and this becoming of lawful child, it is for all the purposes, including the inheritance rights and coparcenary rights. And this effect we have seen from the language of the Bare Act that it is from the date of adoption. Here, for all purposes, it ensures that there is a complete integration of the new member in the family, in the adoptive family, right? Okay. We have to refer to Sita Bai versus Ramchandra, which was decided by the Supreme Court, Honorable Supreme Court in the year 1970. It will tell you how Section 12 actually takes effect. What is the force of Section 12, right? So in this case, what happened? There were husband and wife, and husband also had a brother. Okay, and there was a joint family property, coparcenary property was also there. Then husband dies before there could have been a partition. Now there was, after his death, there was only one copartner left, that was B. I've told you that the sole surviving copartner enjoys the property as his own property, unless there is a new member added to the coparcenary, right? So what happens after several years, after the passing of several years, wife he adopts X, she adopts X, right? A male person, and now it is being argued that this adoption will create coparcenary rights also in favor of X. Now, after adding X to the family, B's sole surviving coparcenary status will be impacted, and now the property will again be converted into a joint family property as per the rules, right? But it was argued that since the adoption took place after H's death, and the we cannot say that he was the he can be said to be the son of H as such. We can only say that he is to be treated as son only of W, only of the adoptive mother. But the court rejected this contention after referring to section number 12. And when it referred to the language of section 12, it said that section 12 clearly prescribes that for all the purposes, the adoption will create all the rights in favor of the child who has been adopted, right? So it does not matter that the adoption took place after H's death. W continued to be the member of this family, and as the member of this family, she has adopted a son, and now this son will form coparcenary with his uncle, right? So here the court gave full effect to the intention behind section number 12. Here, I also invite your attention to another Supreme Court judgment, though it was 1 year prior to this one. And this particular judgment, it talked about the scope of coparcenary, but within the observations, one can also find reference with respect to adoption being made. So the case was State Bank of India versus Ghamandi Ram. And if you want to understand the nature of coparcenary and incidents of coparcenary, this case is a um, must case for you to read, right? Although it deals with the position prior to 2005 amendment where females were not treated as co-partners. And in one of the incidents of co-partnership being discussed in the judgment, you will find reference only to the male co-partners. But apart from that, all the other incidents, they still continue, right? And you can always refer to the judgment if you want to understand how the co-partner is created, what is the nature of co-partnery, and who all can claim rights and what kind of rights are available to the co-partners, right? When court was examining the law relating to coparcenary, in one of the paragraphs, it mentions that a coparcenary is a creature of law and cannot arise by act of parties except insofar that on adoption, the adopted son. Now, this son has to be read after 2005 amendment. This son has to be read to include daughters also. And on adoption, the adopted son becomes a co-partner with his adoptive father as regards the ancestral properties of the latter, right? So, on adoption, under Section 12 also, the rights will be created in favor of the adopted child, be it co-partnery or otherwise. If there is a co-partnery property available and he comes within the top four generations, he or she, and they will enjoy the rights of co-partners, right? Now, Section 12, the second part of Section 12, which provides three exceptions um, to these effects taking place under provisos A, B, and C. Now, we need to examine this in order to understand the complete intention of the legislature, right? So let's see them. First proviso A, provides that the section 12, the main provision, it is subject to these provisos, right? First proviso number A, says that the child cannot marry any person whom or he or she could not have married if he or she had continued in the family of his or her birth, right? So for a valid Hindu marriage, as per Section 5 of Hindu Marriage Act 1955, five criterias along with the ceremonies of marriage have to be satisfied. The last two criterias, they are related to certain prohibitions in terms of prohibited relationships and sapindas, right? They are based on relationships. So for the purposes of marriage, as per Proviso A, the relationship with the previous family still continues, right? मैरिज के पॉइंट ऑफ व्यू से वो रिलेशनशिप क्या होगा, कंटिन्यू चलेगा, कंटिन्यूअसली चलेगा, राइट? बिकॉज अदरवाइज if this thing is not prescribed as an exception, then there can be absurd results, and it will challenge the traditional norms of Hindu society, right? So we do not, nobody would want that from to happen. So proviso A says, for the purpose of marriage, for the purpose of limitations concerning marriage, the relationship will be said to have continued even with the previous family. So if a person could not have married a person from the previous family, um, reason being that the relationship between them is either prohibited or they are subinda to each other, or subinda of any common ancestor, right? Still, these limitations will continue. Then proviso B says any property which vested in the adopted child before the adoption shall continue. This was the position under traditional Hindu law as well. We have understood, right? Once the property vested in the person, subsequent adoption will not divest him from such property. Proviso B is a recognition of the same traditional Hindu law principle, right? It will continue to vest in him. It also provides that it will be subject to the same obligations which were there, right? Including the obligation to maintain relatives in the family of his or her birth, right? This is another principle from property law, that the limitations they run with the rights, right? So vesting of rights, if it comes with limitations, the limitations will run with the land, with the property. So it does not matter whether you have changed your family. If the property still vests in you, the limitations will also continue. Limitations are um, they run with the property, right? Proviso C. The adopted child shall not divest any person of any estate, which means any property which vested in him or her before the adoption, right? Now, for this, I have an example for you here. Hmm. We'll be able to understand Proviso C through this example, right? It will be much, much easy. Here it says a Hindu widow, right? There was a husband, wife, and husband died, right? And wife was the only heir available in this case. So his property will go to the wife, the entire self-acquired property, and including any share which he might have gotten from the joint family property as a co-partner, right? All of that will go to the wife, to the widow, as the only heir available, right? After this happens, right? After the succession has taken place and now the property is with the widow, thereafter she adopts a son, right? Now a son is adopted. So as per Proviso C, this son, this son cannot challenge any kind of alienation made by the widow, either before or after such adoption. Why? Because Proviso C clearly prescribes that upon adoption, the effect of adoption will not be over the already vested properties in somebody else also, not only the adopted child, right? If a property was vested already in some other person, the adoption will not affect the vesting of such property, right? So in this case, when the wife got the entire property of the husband, she will get it as if now the property completely belongs to her, right? She can do whatever she wants either before the adoption or after the adoption. Any alienation can be done with respect to the same property, and S will not have any right because there is proviso number C. Similarly, if in the adoptive family there was already a partition that took place and all the rights were vested, now after adoption, the child cannot, be it son or daughter, cannot challenge it because the properties are already vested, right? Also, if you go by the language of section 12, the main provision, it says the adoption takes effect from the date of adoption, right? All these rights will be created from the date of adoption, right? So in the context of Proviso B, we have a case where the word vested means indivisible rights, which we already know that it refers to the 100% ownership, right? No need to get into the details of the same, right? So this was section number 12, along with its exceptions, along with its provisos. Then another effect which a valid adoption has is that once a valid adoption takes place, it cannot be cancelled. As per section 15, right? Section 15, एक बार देख लेते हैं. Let's give a glance to it. Section 15, it says valid adoption not to be cancelled. There is a clear directive from the law here, right? Nobody can cancel it. No adoption which has been validly made, which means which is as per the provisions of the Hindu Adoptions and Maintenance Act, can be cancelled by the adoptive father or mother or any other person. Now, this any other person, this phrase includes the person who is giving in adoption, right? The father or the mother, the natural father or the mother, right? Nor can the adopted child renounce his or her status as such and return to the family of his or her birth, right? Nobody is allowed to cancel it, including the adoptive father, adoptive mother, the parents who gave in adoption, and including the child himself or herself. They cannot just renounce their status as the child of the new family, the new father or mother, and after renouncing this status, they simply return back to the original family, this cannot happen. As Section 15 says, yeah, this is obvious for practical purposes, right? Once an adoption is validly taken place, it has validly taken place, it should not be cancelled, right? Section 15 makes it a very clear-cut directive that nobody can cancel, including the person giving in adoption, taking in adoption, and the child himself or herself. But here is a catch. Initially, I told you that I'll be referring to section 4 and 5, which, when read together, they will tell us what is the scope of what is the operation of Hindu Adoptions and Maintenance Act, whether it is prospective or retrospective. And there I mentioned that it has prospective application, right? So section 15 has a prospective application. Now, let me just refer to sections 4 and 5. Section 4, though it talks about the overriding effect of the act, that now all the previous laws, rules of interpretation, etc., they will be replaced by the provisions of this act, right? But when we read section 5 along with section 4, we find that no adoption, it provides that no adoption shall be made after the commencement of this act. So these words, after the commencement of this act, actually makes the operation of Hindu Adoptions and Maintenance Act prospective, right? They are not retrospective. So section 15 also has a prospective effect, which means that if there was a practice prevalent in any section of Hindu society where after a valid adoption, the adoption could be revoked, the adoption could be cancelled, right? The previous adoption, the previously taken adoption, uh, will continue to be governed by the previous law, right? So even after the commencement of this act, if the adoption took place before 1956, right, and the law provided an exception, law provided that it could be cancelled either by the child himself or anybody, either bilateral thing or unilateral thing, right? It will continue, and the same right prevails even in light of Section 15. And the same thing was recognized by the Supreme Court in 1975 in the case of Dani Raiji versus Vahuji Maharaj Chandra Prabhu, 1975 Supreme Court. Here, the issue was the adoption, it took place prior to 1956. And the kind of adoption that took place, it permitted the person to unilaterally give up his status as the adopted child, right? So the issue was whether now this can be allowed in light of Section 15. So the court clearly said that Hindu Adoptions and Maintenance Act, it has a prospective effect, and the adoptions that already took place before 1956, they will be continued to be governed by the previous traditional Hindu law, right? So even after the overriding effect under Section 4 of Hindu Adoptions and Maintenance Act, the traditional law still continues to be relevant, right? So in this particular case, the right survived, the right to cancel, right to give up the status um, of being an adopted child, it survived even after the Section 15, right? Now we come to the last aspect under the effects of valid adoption, and that is related to the issue of reservation. I pointed this out right at the beginning when we started with this topic, that adoption has a direct bearing on the issue of caste, and which in turn is related to the issue of reservation. Here we will be referring to some of the important judgments both by high courts and Supreme Court, um, to identify what is the position with respect to this issue. However, however, before going into the facts and what were the observations made by the courts in these cases, let me just put this before you, that as a judge, as a judicial officer, or even as a lawyer, when you are faced with this kind of issue, ask two questions to yourself. First, whether there is a genuine adoption that has taken place or not, right? Whether the essentials of Hindu Adoptions and Maintenance Act, they are fulfilled or not. If the answer is yes, right, then you move on to the second question. Ask yourself whether I should be bothered by the purpose or the intention behind adoption. The the crux of these judgments is that the motive behind the adoption, it is completely irrelevant. Even if there are people who want to take advantage, in the sense that not through fraudulent means, obviously, if there is a complete transformation, complete transplantation from one family to the other, the natural consequences as per section 12 will be that he will be treated as a member of the new family for all the purposes, including the caste, right? So whatever is the intention purpose behind it, if there is a complete and genuine adoption, in the sense there is a complete assimilation of the adopted child in the new family, right, then we will not get into the motive behind the adoption, right? After going through these observations, things will be more clear, but these are the fundamentals. Whenever you are faced with this issue, ask these questions. Should I be bothered about the motive? The answer is no. As per these judgments, the answer is no. Second, should I be testing whether there is a genuine adoption or not? Right? The answer is yes. You should look whether the adoption is genuine or not. And how will you identify that the adoption is genuine? By seeing that whether there is a complete assimilation of the person in the family or not, whether the provisions of Hindu Adoptions and Maintenance Act, they are fulfilled or not, right? That should be your point of inquiry as judicial officers, as lawyers. So, with this, now let's see what has happened in these cases. First, we have a case from Rajasthan High Court, Vikas Soni versus Malwe Regional Engineering College. Right, it was decided in 2003. Right, so what happened in this case? The petitioner Vikas Soni, he applied for taking admission in an engineering college, and the category in which he applied, he made an application, was children of defense personnel killed. Now the issue here is, though Vikas Soni was an adopted child, right? The facts were somewhat like this: the father was in defense, and after the death of father, the mother adopted the person in question, that is Vikas Soni. Right? Now, as per section 12, his contention was, as per section 12, after the adoption, I should be treated as the son of the father also, right? And the tries are now created with the entire family, not only with the mother, right? So he claimed his eligibility was based on his adoption by Sushila Devi, the wife of the army personnel, right? Who was the widow of late Shri Hajari Singh. So Hajari Singh was actually the person in defense, right? So he was killed in 1965. He was a soldier, right? Vikas Soni presented all the certificates confirming his adoption, right? And he has been consistently using his adoptive father's name throughout his educational records, right? So both the documents were in his favor, and the conduct of the person was also in his favor. But his application was denied by the educational institution, and it was alleged by them that the benefits under this category will only be available to the naturally born son, not to the adopted child, right? So here the court deprecated this kind of attitude, and it made several important observations. Justice Rathore was presiding the bench. Uh, According to him, an adopted child is deemed to be the child of the adoptive parents, again, for all purposes, right? And this includes inheritance rights and eligibility for benefits available to the adoptive family. Here, the facts were such that he got completely assimilated in the family, and he was using his adoptive father's name, the deceased father's name, throughout his educational purposes, right? Right. So, for all purposes, he should be treated as the son of the person, and consequently, the benefits under the reserve category must be available to him. Then, the Justice Rathore also address the contention of the institution that only natural born children could claim the benefits under this category. Right, Justice Rathore said that such an argument contravenes with the provisions of adoption law, the aim of which is to integrate the adoptee fully into the adoptive family. Right, if we decide otherwise, it will be a complete, um, we will be completely ignoring the intention behind the law. Okay. Now, the next case we have is from Andhra Pradesh High Court, right? Case of A.S. Selja versus Principal Kurnool Medical College, right? Somewhere you will also see in this case being referred to as Principal, KMC, right? A.S. Selja. It is the same case. So in this case, A.S. Selja actually, she took birth in a Brahmin family, right? We all know that it is a higher caste in the society. But later on, she was adopted by a Yadav family in 1982. Okay. After that, she applied to a medical college under the backward class D reservation quota, which was available for the Yadavas. She claimed that she severed all her ties with the natural family, and as per Section 12, now the benefits will should be extended to her as well, because now she is the member of a Yadav family and not the Brahmin family. But her application was rejected because first the institution was of the opinion that this is a motivated adoption, and the adoption is made only with the desire to secure admission by way of taking benefits under reservation policy. Second, they said that the application is also rejected on the ground that she was not assimilated into the backward community. Right? Actually, what happened was even after the adoption, Selja continued to reside with her original um, family, and she was never with the adoptive parents. She continued to reside in the house of the previous family. So there was no, clearly there was not a genuine adoption here. And though motivation, as I've told you, that motivation was not needed to be looked at, but yes, genuinity of the adoption was surely one should consider. And in this case, the court also found that it was not a genuine adoption. Justice Ramaswamy, he penned down this judgment, and he remarked that in this case, adoption appears to be calculated move to gain reservation benefits rather than a genuine integration into the backward class. Again, the emphasis is on the genuinity behind the adoption, right? मोटिव से कोर्ट को इतना फर्क नहीं पड़ता है, but at the same time, the court should not allow such frauds to happen, right? So genuinity has to be examined. Then we have a case from Delhi High Court, Khazan Singh versus Union of India. Again, a very interesting case. Here, the boy originally belonged to a Jat family who was given in adoption to a family friend and a business partner, and he actually belonged to SC category. So the father, the natural father and the adoptive father of the man in question, they were the business partners running a dairy business in West Delhi, and the Jat family had four children, including Khizan Singh, and the other partner had none. So it was decided that they had very cordial relationship. It was decided that one of the sons can be adopted by the other person, and everybody can lead happy lives, right? So after this adoption, naturally the son claimed benefits of reservation, and he got into Delhi police under the reserved category. But one of his friends actually complained against him, stating that it was a sham adoption and only the reservation benefits are intended to be taken, and he should be suspended, he should be removed, and his caste certificate should be cancelled. Right? When proceedings were pending before the department wrote to um, the committee, the authority responsible to for issuing these certificates, and it was the subdivisional magistrate, right? And after receiving such a communication from the department, the caste certificate was also cancelled. So in these proceedings, the cancellation of the caste certificate was the issue, and it was argued on behalf of the petitioner that as per Section 12, for all the purposes now, the ties are created with the new family. The Delhi High Court made a detailed analysis of the caste and effect on caste by way of adoption. And it laid down these four things, very important things. Again, the emphasis is on the genuinity and not the motive behind the adoption. Right? The first thing that comes out from the judgment is, if the adoption is valid and a genuine one. Valid means it has satisfied all the provisions of Hindu Adoptions and Maintenance Act. Genuine means there is a complete assimilation of the person in the new family. The motive is of no consequence. We will not look at the motive. Why? Because reason for this we'll find in the last observation made by the court, that genuinity only is required to strengthen the social equality aimed in the constitution. Right? Aim could Purpose could be anything, but if the adoption is genuine, it will increase social equality, which is one of the intended purposes of the constitution. Right? Then it has also talked about that how, for how long we should be denying benefits to such a person. Right? It should not be done. If the adoption was genuine, Section 12 has to take effect. So the court ordered the authority to reinstate the person in the same category, and issue new certificate to him, or just cancel the cancellation. Okay. Last case we have is the case of Valsamma Paul versus Cochin University, decided by Supreme Court in 1996. Though the issue was not related to adoption directly, right? It was actually change of caste in case of intercaste marriages. So court was dealing with the issue of change in caste and benefits being taken by one of the partners in case of intercaste marriages. What should be the law with respect to the same? And while analyzing the law relating to it, the court made a passing reference to the Delhi High Court judgment in Khazan Singh versus Union of India. Right? It was just a passing reference. And you will find that the court said that Khazan Singh does not lay down the correct position of the law. But since the issue was completely different, we cannot say that this observation made with respect to Kazan Singh is a binding observation. We can only take it as an obiter dicta, and as law students, we are aware that obiter dicta, they are not binding, right? So this passing reference implies that the main focus of this ruling was not on the correctness of the Kazan Singh case, right? But on the specific matter of caste changes through the intercaste marriages. So that way also we can say that it is not a binding precedent as far as overruling Kazan Singh is concerned, right? So Kazan Singh still survives. Okay. Okay. So with this, we come to an end of today's class. I hope you enjoyed it thoroughly. And now I open the forum for doubts. And eh, till the time you people type your doubts in the comment section, let me just quickly inform you about the course that Livelaw Academy has come up with. It is a very comprehensive course which is designed to cover more than 40 subjects, which will be beneficial for you as a practitioner, as a law student, as a person who is aiming for judicial services examination. And the benefit for enrolling in this particular course are numerous. For example, you will be getting practical experience from the uh, very experienced retired High Court judges. You will be getting live sessions as well as recorded sessions. Then digital notes will be provided to you, and you will also get the free subscription of Livelaw, and there will be uh, very interactive doubt clearing sessions uh, and regular tests. Right? I don't think a candidate needs more than these things to succeed in these examinations. So, with this information, I invite you to explore this case on the website, or this course on the website, and hopefully, we'll meet very soon in the classes or in the next session. Okay, is there any doubt? All right then. See you. Take care. Bye bye.
अरे चाय वाले भैया, जल्दी से गर्मा गर्म समोसे खिला दो।
मोटू, तुम्हारा पेट ठीक नहीं है, तुम्हें डॉक्टर